Good afternoon, everyone. Thank you for joining me today. So what we're going to discuss is, how to modify a custody order. So I like to start out with, it's very simplistic. Well, what's an order? Okay, well, an order is a signed order from, in modification issues, family court or Supreme Court, okay, that deal with custody. Now, a lot of people would contact me at times, or they would go to court and they would say, well, wait a second, we have a separation and settlement agreement here, and this says specific things about custody and parenting time, or they've written something else themselves and they both signed it and had it notarized, and they'll go into court and they say, well, he's not filing this agreement, so therefore we want to violate him. We want to modify the agreement, or we have someone come into court and they say, well, wait a second, XYZ, mom or dad, filed a petition for a custody order. And they say, well, wait a second, I have this separation settlement agreement. Now, what you got to realize, separation settlement agreements or signed agreements between parties, those are contracts. They're not orders. Okay. They have no bearing in family court or Supreme Court until they become court orders. That's not to say that some judges might look at those and say, geez, people have been following these guidelines for about 2 years, and now someone wants to take away rights of another party when they file, say, for a custody petition in family court. The court's going to look at that agreement, of course, but it said you can't contract away your rights, your children's rights, separation agreements, and stipulations. They're contracts. They're not orders. So first things first, remember that you have to look for an order. Now, you have a family court custody order, okay, and you have a Supreme Court custody order. Now, Supreme Court custody orders all the time come out of parties during a divorce where they have children, and they either litigate the custodial matter and the court enters an order, or they have a separation settlement agreement. Everybody says it's fine the way it is. And then they enter that along with the judgment of divorce. The court signs the judgment of divorce, incorporating that agreement. So therefore, then you have a Supreme Court custody order. And then if you go to family court and you file for what's called a de novo, a brand new custody proceeding, or you've modified a previous order of custody, okay, you have the family court custody order signed by the judge. So therefore, the first thing you look at, we have orders that are legitimate orders. All right. Then the next thing that we're going to be looking at is, let's talk about, if you can flip over, let's go to parts of a custody order. Okay. So what's in a custody order? So you have a custody order, and in that custody order, if it's a good custody order, because there's a lot of bad custody orders out there, there's 3 types of custody in New York State. There is sole legal and physical custody to one party. That is where the child or children live with one party, pretty much primarily with that one party. The party who the child lives with does not have to discuss any health, education, or welfare issues with the other party. They make all the decisions. That is pretty much far and few between, never happens unless it's a really bad relationship between the mother and the father. There's no communication. There's some very adverse things going on. Secondly, what you would look at is for custody is joint legal custody with the child or children living with one of the parents and the other parent having visitation, parenting time with the children. And then you also have in New York State what's called shared legal and physical custody, where the parties go ahead and they split the time with the child equally. Okay, so you start off with custody. So in your first custody order, when you're doing your first one, that you might change down the road, you have in there your legal custody. Now, physical custody means how much time does the child spend with either parent? Okay. Do they spend half the time with each? That is 50-50 shared custody. Do they spend 4 days with one and 3 days with other during the week? That's a custodial schedule. And when you're doing a custodial schedule, in New York State, it used to be years ago that, I would say that a lot of times the physical custodial arrangement did favor the mother in these type of cases. Custody now in New York State, the way I've been seeing these cases, and I tell all my clients, you start here, equal, all right? Now, tell me why, tell the court why it should move in either direction, up or down, for one of the parents, all right? And then that comes to physical custody. Now, physical custody, now, if you let a judge decide that, the judge will go along, hear the proof, make a determination. I always think it's better if the parents can co-parent to make out a schedule that benefits both of them. Okay, it is proven by plenty of doctors, psychologists, psychiatrists that children benefit from being around both parents, as long as, of course, as you have loving parents who aren't going to, alienate the other, say bad things about the other. They don't have any bad habits or things like that. Both of the children do thrive in those type of situations. And then visitation schedule. Now, visitation schedule could be anything from, put in what time. We have a schedule. What time do you pick the children up? What time do you bring them home? Where are you going to drop off the children? Where are you going to pick up the children? So always remember, when you have a visitation schedule, be as specific as you can. So down the road, you don't have to go back to court because the visitation schedule is not working. Perfect example, sometimes people put in their agreements, well, we're going to have parenting time as we can mutually agree. And that all works well. But then down the road, okay, basically, what does mutually agree mean? Now, the courts have said, in many cases have said, mutually agree means if one person doesn't agree, the other person doesn't get. So let's say that dad has primary custody of their child, and they say, mom and dad will mutually agree upon visitation for mom. So mom calls up and says, hey, I'd like to see our son this weekend. Dad goes, no. And mom goes, why not? She goes, because I don't agree with that with stuff going on. The next thing, so mom says, okay, then she calls up following weekend. I'd like to see, we put something together for this weekend. No. Well, why not? She says, well, we have things going on. So remember, if you can't mutually agree, you don't get, and you can't violate somebody for not mutually agreeing. People say, well, it says mutually agree and I can't get any time, I'm going to violate them. You can't violate somebody for that, all right? So always you can go back and modify the order to get a better schedule. And that's one of the things you would go back, how modifying an order, say you have something like that. That's a mutually agree, and one party or just limits the other party's time, so down to hours or maybe one overnight, not even something. And the other party said, well, I thought we could work this out. And the other party, well, we can't work it out. Then that's a basis to go back to modify that schedule, because you can't mutually agree and you need a set schedule now so you can see your child. Right? So when you do a visitation schedule, make sure you really think everything out about pickup, drop off, time. Is it a pickup at school? You know, and then the next thing, let's talk about holiday schedules. All right, that's very important. Now, when I do my agreements or orders, I have probably about 3 pages that deal with holiday schedules. So I pretty much don't leave any stone unturned. Um, I try to be very specific. Are you going to share holidays? Where are you going to exchange? Where are you going to pick up? The time it starts, the time it ends, all that. We have Thanksgiving. You know, we have Thanksgiving. We have Easter. You could have Hanukkah. You could have, you know, any other type of religious holiday on top of kids getting off from school. You know, kids' vacations from school, summer vacation. All right. Um, Goes on and on and on. If you don't, now a lot of people say we don't need to be specific. I like being specific. The more specific you can be, the less chance it is that someone's going to be able to modify that custodial order. Now, school related provisions, basically school, you know, each party, you know, has a right, of course, under the law, unless an order says otherwise, to get all information from school, doctors, pharmacists. But what I always do, now some doctors or schools, you know, they're not too savvy with these orders. So if it doesn't say specifically that dad or mom can get information regarding the child or speak to the children, they don't put it in, they won't do it. Okay. So what I do, I always put in my agreements that, you know, so whoever's a primary custodial parent, XYZ parent will sign any and all releases with the children's school, doctors, dentists, healthcare providers to allow XYZ, the other party, to get any and all information regarding the child X, Y, and Z. It just cuts down on problems in the future. Okay, now, I say that because what I just spoke about is a lot of reasons you see people going in to modify a court order. Okay, so let's go to the reasons to modify a court order. All right, so get back to what we we're talking about just a few moments ago, reasons to modify a court order. So reasons to modify a court order just can't be, well, I don't like it anymore. Okay, I want to change this because I don't like what I agreed upon and I just don't like it. Okay, I don't like it isn't a way to isn't going to modify a court order. Okay, my 6-year-old son or daughter doesn't like going to dad's or mom's anymore. Therefore, I'm going to modify it because my 6-year-old doesn't like this anymore. Okay. Well, the first thing, if you put that in a petition, the judge is first going to say, well, Mr. Belsky, first thing I'm going to tell you, 6-year-old doesn't determine what's best for them. And they don't get a say in what's best for them. I'm going to decide, if the parents can't decide, what's best for this child based upon the testimony I hear. So make sure that when you have reasons to modify it, there are good reasons, basic reasons. For instance, let's just say mom and dad, they have a child, they separate, and mom, and they have, let's just say they have joint custody, mom has primary custody, but dad has an extensive visitation schedule, including weekends, overnights. So everything's going great. And dad gets a girlfriend. Girlfriend moves in the house with dad. Of course, the child's spending the weekends there. And mom says, I don't like that. No reason why, but I don't like that. I don't think that's right. And I'm going to modify this petition. So mom just writes The reason I want to modify this petition is because um, dad has a girlfriend. Let's just take it a step further. Let's say mom talks to the child, and she just said, "Well, how do you get along with dad's girlfriend?" And he goes, "Boy, it's great. Helps you with school. The child's coming home clean. You know, mom really has no concerns about the child, anything going wrong with the child, but she just doesn't like it, and she puts that in her. That's the change of circumstance. Dad's got a girlfriend. That's not going to get past the front door. Okay, you'll walk in, that'll get kicked out by the court, dismissed. Now, let's take a step further, and we say, okay, dad gets a brand new girlfriend, and the girlfriend, um, the child comes home and says, "Geez, mom, something's weird." And mom goes, "What's going on?" She goes, "Well, I sleep in bed with dad and his girlfriend because the new girlfriend has a, a child that took my room." Okay, red flag, red flag. Okay. Secondly, what we have going on, and she goes, "Oh," and the child goes, "Yeah," and this mom, this dad's girlfriend, uh, she's always smoking this stuff in the house that kind of smells uh, like real stinky. Oh, she's okay. And then we also have, then we find out that dad's new girlfriend is just released from jail because she uh, some violent crimes. Okay, so now we have a girlfriend, but now we have a girlfriend who has a lot of baggage and a lot of bad stuff is going on for the child. All right, no question at that point in time, you file your modification petition, you have a basis to file that modification petition. And this is going to, no question, lead to some certain changes in a type of custodial order. So when you look at, modifying, an agreement, really look at what you're trying to modify and the reason why. Okay. So other things people do to modify agreements is because they're moving, they're relocating, right? And there's a certain standard that has to be shown. There's a two-pronged standard that has to be shown to allow someone to relocate outside, let's say, the capital district with the child to, let's say, Florida or somewhere else. All right. Let's just say that we filed to modify because now I'm going to move from Warren County down to Albany County. And I say, well, we used to both live in Warren County. Now we're going to Albany County, and it's too far to keep this schedule. So something has to change. Now, some judges might look at that and they might say, there's no reason to change this. I mean, you can meet halfway, or there's ways to deal with this. Or the judge could say, well, we have to take a look at this case because you are moving and, the child is in school. So to get the child up, if you're, wherever the child's going to school, say the child goes back to school down here, down in, and say Albany County or somewhere, to get the child up at 4 a.m. to get ready, dress, and drive from Warrensburg or Warren County down here. These are things you have to really look at. Now, the biggest thing when you're looking at these type of agreements is it's a two-pronged test. And this is a thing that nobody really understands, is that number one, when you file for a modification of a custody order, all right, you have to show what has been the significant change of circumstance. Okay. Now, that's kind of open to interpretation by a court and by a judge. And I see it happen all the time where some judges will say, well, that's nothing, forget about that. And then other judges will say, geez, that's a big change of circumstance. And, you also see this happen a lot between counties, Albany County, Saratoga County, Rensselaer, Schenectady, Schoharie County. You'll see that different judges in different counties look at things a little differently. Some are a little jaded on things, but that's just part of the territory, and you can't forum shop. Okay, you can't say, well, geez, I don't like my Warren County judge, and we live up here. I'm going to go file in Saratoga County or somewhere else. You can't do that. The law doesn't let you do that. All right. Now, what other instances to modify? Violating an order. Now, what you have to realize is that, let's just say we have a mom and dad. Let's say this time dad has primary custody, mom has a parenting schedule. Mom's parenting schedule, let's just say it's 3 days a week, overnights, or let's just say stuff like that. Now, so they put it all together, and then we start the schedule, and mom doesn't see the child 3 days a week. I don't know, she takes one, and maybe she'll miss the next week, and then the week after she'll take two, or she'll take a half a day and not an overnight. Okay, so I get a call lots of times where the client will say, Mike, we have a court order from family court. It says this is her parenting time. Said, I want to violate her because she doesn't take this parenting time. You can't violate someone for not exercising their parenting time, or the non-custodial party not exercising their parenting time. Even though it's a court order that says this is what they get, it's not an order that says they have to do it. And lots of times, I have a lot of clients that come in who are working, say working moms, working dads, and they have this schedule in place. They really thought out this schedule because, they said, geez, if I can get this schedule, then I can work my schedule around mom or dad seeing the child on her days or his days, not on my days. So maybe I can work a double shift. And so they look at that, go, oh, this will work out. And then all of a sudden, mom or dad doesn't take their days. They blow off their time. And then you have mom or dad scurrying for daycare, losing time at work. So is that a violation? No. Is that a basis for a modification? Most definitely. Okay, what the court's going to look at there is when something like that comes along is, all right, so we need a more set schedule. So the parent who is not, I shouldn't say violating the order, not going along with the order, to make sure that they can have a schedule that they can rely upon, so they can work, they can get daycare if needed, they can find household help, they can maybe move their schedule around. But that's when you go to court and say, Your Honor, this is what's happening. This is what's going on. Okay, I need to modify this schedule. Now, that's basically a modification schedule based upon things of that nature. Other ways to, when you file for a modification, and what you have to do is when you file for a modification, you have to set forth in your petition, it's a family court petition, and you have original petitions where you set forth to the court what the facts are, okay, and why it's in the best interest for the child to be with whoever files or not, give anybody parenting time on the other side. Then once we have that, then we look for a modification. And you go back to the modification, you have to also go back to, I want to modify this order twofold. Let's go back to the father who has a girlfriend who, smokes dope and, is just let out of jail. So the first thing you're going to file and say to the court, I need to modify this petition. And there's been a substantial change in circumstance from the last order. Remember, I'm going to get that in a second, from the last order. And they're going to say in my papers, what is that change of circumstance? Well, number one, dad has a new girlfriend, which in itself is not going to be a basis to modify, but the new girlfriend, upon information, is smoking marijuana in the house. She's a convicted for violent crimes. The child is now sleeping with this girl and dad in the same bed. And then, so there's your substantial change in circumstance. No question, from dad being alone with the child to this happening, that's substantial. Okay. But then the next thing you have to prove in your modification, and it's very important that you put that in there because a lot of people don't do it. A lot of attorneys don't do it. Why is it in the best interest of the child to change the order? That's very important because if there's a change of circumstance and you can't show the judge why you need to change that order, because that's being the best interest of the child also, you lose. It's a two-pronged test. Remember that. Okay? No question in the scenario I just put together, no question it's in the best interest of the child to have this modified. But, when you see things that a lot of people put in their papers, well, this is the change of circumstance. Okay, let's go back to previously. What's the change in circumstance? Well, mom has a boyfriend and the boyfriend lives with mom, and the boyfriend has a 16-year-old son that's at the house. Okay, but mom knows that the guy's a hardworking guy. Maybe he's a police officer. Maybe his son is on the varsity football team, all straight A's and doing great. But mom doesn't like the fact that there's a girlfriend or a boyfriend at that house. So we put all this in there as a change of circumstance. Okay, but why is it in the best interest to change that custodial arrangement with the father? Well, there isn't none. Say you have, a 16-year-old who's great at school, straight A's, nothing ever happened to him. We have someone that's, works hard, no background, no drug, alcohol issue, no CPS investigations, anything. And so the court's going to look at that and say, okay, you have a change, but you can't, there's nothing here that's not in the best interest that dad or mom has to get their time taken away just because of that. So remember, always look at a two-pronged test. And what I always kind of do first with my clients is say, okay, let's start off with the best interest. Why should we change this? Why is it best for the child to change this? And then I try to go into the facts. Because if you don't get the best interest standard, you're not going to go anywhere. Now, that being said, a lot of judges out there that kind of just blow right over that. Okay. And they'll wait till you go to trial so they can hear the proof to determine if there's best interest or not. When a lot of them should be looking at these petitions and right off the bat saying, I see the change of circumstance, but I see no best interest here. And that's up to the attorney to argue if you have attorneys. But a lot of people, as we know, file their own petitions. And when somebody files their own petition, that's called self-represented litigant, the courts have to give them the benefit of the doubt because they're not attorneys in filling out their papers. Okay. So when they look at this and there's really not a big best interest or stuff, the judges will keep it going, move it forward. So if you have a good attorney, then that attorney is going to make a motion to dismiss based upon there is no change of circumstance. Okay, why there's no best interest for the child. All right. Again, I see that happening differently in different counties and different judges. Okay. Everybody knows that we have the.
All right. Our first course code is 353735. Again, that's 353735.
Okay. So just getting back to, modification petitions, a lot of the thing is that I'm going to, say this also that, so this is what we're just talking about. best interest, change in circumstance, moving from the county or state, remarriage. It isn't really a change of circumstance, to be honest with you. People think it is, unless there's something wrong with the person that the other party's marrying. Like I always ask my clients if they have boyfriends or girlfriends, the three questions: any drug issues, any alcohol issues? Well, it should be four questions. Any domestic violence issues, any CPS, Child Protective Service findings against those parties. Those are the kind of big four taboo that the judge is going to look at if there's something to look at. All right, as far as any type of person that you start to live with or get married to. Another thing that they'll look at, which is one of the parents bouncing from house to house to house to house over a period of time. So a child does not have any stability, number one, in the household or in the school district because the parent keeps moving. Okay. Does the parent keep moving with the child and bouncing from boyfriend to boyfriend to boyfriend or girlfriend to girlfriend to girlfriend, just keep bouncing around over a 2-year period? Number one, is that a substantial change in circumstance? Yes, it is. The next question, is that in the best interest of the child? I think we can all say, no, it is not. All right. Remember, two-prong test. Incarceration, of course, well, if someone's incarcerated, of course, that's a basis to terminate or modify a custodial arrangement. Even if the person isn't incarcerated, say the person gets arrested. Let's just say the person, especially now with Leander's law, with alcohol, and now with the use of marijuana and drugs, say someone gets, we all know what that is. You get pulled over, child under 16, okay? In the car, you're intoxicated or under the influence of drugs or alcohol, automatic felony, okay? Of course, the court's going to look on that very harshly because you had your kids in the car and you're out there that way. Where if you got yourself a DWI, are they going to look at it as harsh? No, but it's still going to be a change in circumstance, okay? Now, allegation of abuse of the child, serious injury or illness to the child, whether in your care. If it's not an accident, of course, accident happened. Communication is a big one now, where you're supposed to in a modified order, or in an order. Like I said, my orders that I do. Not only then, we also spell out in detail communication between the parties. When can they call each other? When can they talk to the child when the other party's care? Is it FaceTime? Is it by telephone? We put in there also, if either party is going to go out of New York State, say we have a young child, they have to let the other party know where they're going and how long they're going to be gone for. Lots of times, if someone sees, let's go over to Boston, at a great aquarium over there. Okay. But you should let the other party know. Say if someone's going on vacation, if they're going somewhere in the US, their itinerary, their flight plan, where they're going to stay, make sure that the other party can communicate with the other party. If they're going out of the country, making sure that the children have passports, making sure that the other party knows where they're going, where they're staying, and they get an itinerary. This is all in my agreements. Also, in my agreements, we also, put in there a lot of information regarding talking to each other, talking to doctors, being able to get information. Lots of times you see the biggest problem and fight between parents is lack of communication. And lack of communication regarding doctors, illnesses, school functions, extracurricular activities, sporting events. One of my biggest pet peeves, and I always put this in my agreement that it shouldn't be done, is, one parent, so one parent signs the child up for basketball, okay, and that infringes upon maybe mom's parenting time, but dad never said to mom, "Hey, is it okay if we do basketball? Can you go? And is it okay? I don't want to do anything that infringes on your time. If I want to do something with our son," but they talk it out. What happens a lot is one parent just takes it upon themselves, enrolls the child, and they say, "Hey, you want to go to play basketball?" And the kid goes, "Yeah, that would be great." So they put the child into basketball, and it happens every weekend that, say, mom has the kids, say for her parenting time, she has to take the kids to basketball practice. So her whole day is gone. Okay. She has limited time with the kids. Dad doesn't ask her. And then that makes mom look like the bad guy if she says to the child, "Well, we're not going to go to basketball today because we're going to do something else. We're going to go to a birthday party." And then, so that also is a basis for a modification. Those kind of communication issues, right? And that's one thing you'll find with the judges in this area, in every county. Communication, if you fail with communication and you're doing it basically hurting the other party's right to see their children, they don't stand for that. All right. Now, parental alienation. Now, parental alienation is a concept where it's been beaten around and beaten around. What is parental alienation? Okay. People always throw that out, being alienated. Right. Now, there's a whole laundry list of symptoms for parental alienation. Usually, if something like this happens, you get a psychological evaluation of the children and the parties. All right. And what it does basically is that one parent or that parent and his family or his new spouse basically do everything they can to talk negatively about the other parent, try to turn the child against the other parent. It's almost like, you know, I call it grooming for alienation of a parent. Okay. As we all know, grooming for sexual abuse of children with pedophiles. It's not these people aren't pedophiles, but it's the same thing. It's a grooming over time that kind of slowly eats away at the relationship with one parent, and it happens a lot. Okay. And I always tell my clients, if it's happening, get in front of a judge sooner rather than later. All right. That's a basis for modification. That's a substantial change of circumstance. Again, and why is it in the best interest of the child? Because the child should have love and affection for both parents and should not, be tainted against one parent by other parents and family members telling them incorrect or bad things or wrong things. All right. So filing for modification. So let's start with, say you have a Supreme Court order in a judgment of divorce, and in that order is a custodial schedule, custody schedule, parenting schedule, and you're going to always see in your judgment of divorce that it says that Supreme Court retains, and your Supreme Court is where you get your divorce. Supreme Court retains jurisdiction regarding the issues of custody and family custody and visitation concurrent with family court. What does that mean? That means that the party could either bring a contempt proceeding in Supreme Court based upon the court order, or they could go ahead and file for a modification. Well, they could do a modification in Supreme Court also, or they can go to family court. Now, I've been doing this for almost 30 years. I don't know one Supreme Court judge that likes to do family court custody trials. Okay. All alone, especially if you're trying to modify that in Supreme Court, basically where it's all alone. 99.9% of the time, if someone tried to do that, they're going to automatically sign an order shipping it to family court. And also with family court too, they're better apt to handle these type of things. So if you're going to modify any type of an order, family court order, or a Supreme Court custody order, always do it in family court. I stay away from Supreme Court because right off the bat, they don't like to hear these things. That's my opinion, all right? But I think a lot of attorneys would agree with me out there. So what you do, you get your modification petition. Now remember, all these petitions are online. So all you have to do is go into your Google Drive and you put in New York State Family Court petitions, and you get a list of about probably 40 different types of petitions that you could possibly file. One of them is going to say modification of custody. Okay. Now, there's some technicalities, different language you have to do. And when you fill out, if you're going to go to family court and modify a Supreme Court order, then there's certain language you'll see. It's right in the petitions what you have to put in there. And you don't have to do the same really with your just family court orders. Also, if you're modifying a order from another county, you got to make sure that you attach a copy of that order from the other county. So let's say you're filing a modification of a petition, an order from Albany County Family Court, then you would go ahead and you would put that, attach that to your papers. Now, where can you file? And we could do a whole CLE on where you can file. Let's just do it this way. The easiest way to do it. If there's a custody order in place and one of the parties still lives in the county where that custody order was given, that's we have to file. Okay? If neither party still lives in the county, okay, then it would be the person who has primary physical custody is where you would go. That's what I would tell you to do. All right. So then in your order, it's going to ask you specific information, address, name, address, phone number, name of the children, age, who they live with. Is there any previous court order? Is there any domestic violence issues? Are either the parties in the military? Because that's very important. Because if someone's in the military, they're on active duty and they're been deployed, they have a right to hold off and hold on this modification petition for a specific amount of time until they're able to appear either in person. So that's important. All right. Also, what you want to look at is when you get these orders, well, when you get these papers, all right, the amount of space they give you to write, you're lucky you could write 2 sentences. All right. So I always tell my clients, if you're going to do this yourself, and it says, when you look at it, it says, what has been this substantial change in circumstance? Right. What I always tell them to say is see attached A. Okay. And then you get a piece of paper and you put on the top attachment A, and it gives you time to write what's been going on. Because there's no way you can fill in that little spot and say what's been going on or what's been happening in that tiny little space. Okay. So always use extra paper, just as long as you let them know that there's extra paper attached. Make sure you do that. Now, secondly, when I say fill that out, okay, be specific with regards to what's going on, and you don't have to write a whole book. What I mean by that is specifically on, let's just say, one of the reasons on January 1st, 2025, XYZ, father of the child, was driving in Saratoga County, New York, and he was pulled over and he was arrested for Leander's Law. The 2 kids in the car were X, X, and X. I had to go pick them up from the sheriff, or my parents did. Okay. so that's kind of describing what happened, right? Not just father got DWI. Okay, give him a little more information. Make sure you give him enough information to look at. Make sure you give the judge enough information to review and look at, and also the other attorney, and also the attorney for the child. Okay, like I said, don't write a book, but write enough in there. Lots of times you see petitions that say, well, we got in a fight and something happened. Okay, well, you got in a fight and something happened. That doesn't give the judge too much either. Well, on this day, roughly Saturday, January, whatever, came home from work. My partner was sitting on the couch, had a bottle of beer in their hand. I asked them a question about something. I'm going to say he or she got violent. They got up, they threw the bottle at me. I had to call the police, 911. Okay, just to say I got in a fight. Right? They want to know more about it. And I always tell all my clients, think about it and write those things out, because that's what the judge and the attorneys want to see. Right? Give them the information that they need to show that, number one, the two key things: substantial change in circumstance, and number two, why is it in the best interest for the child that we change this? Two things. Okay, let's talk about emergency applications. All right. So an emergency application is basically what we call, it's an application to the judge. It's usually done by an order to show cause, along with a petition, where you ask this judge, a family court judge, saying, here are the facts. Here is the basis for the modification and why it's in the best interest of the child that it be modified. But remember, now, you're doing everything I told you. You're filling out the paperwork. You're really listing what's going on. Okay, everything's going on. You lay it out in detail. If you have a picture and you attach your picture, if you have a text from this person, you attach a text to your papers, and you're asking the judge by order to show cause, without husband, wife, boyfriend, girlfriend, even appearing in court or being here to answer what I'm giving to you, Your Honor. I'm asking you to make a order right now for X, Y, and Z. Okay, so you're saying to the judge, based upon the facts that I put in my papers. Now, again, the judge doesn't know if you're lying or not. Okay, of course. And the other party isn't present to defend himself, okay, about these allegations. But the judge has to look at this and say, okay, well, I have to take the assumption that she's not lying, that these facts are true. And if I don't change or sign an order to show cause, say cutting off one of the parents' parenting time because of something that happened, then there's a risk that this child could get injured, severely injured, or their health or mental health would be severely affected. So based on that alone, reading these papers, I'm going to grant the parties filing request to terminate the father's rights, mother's rights, change the visitation schedule, change the custodial schedule, okay, all of that. So one thing I got to say about that, to anybody that's here and you have clients or something, you better be darn sure that what they're telling your clients are telling you are true, okay? Because number one, and like I said, I've been doing this for a long time, is that the family courts, I have to say, they're somewhat broken, okay? They're trying, but they're broken. For example, let's just say that mom fills out this petition, order to show cause, says all this stuff about dad, okay? But let's just say she she kind of blew a lot of this out of proportion so she could win. And then what happens is that the court says, okay, here's the order to show cause. We signed it today. The earliest we can get you back into the court would be in 5 weeks because we're so busy. So based on that, you have dad or mom on the other side, if it was dad filing, not being able to see their child or children for that amount of time because of one party put into their petition that they've kind of massaged it to the fact where it's wrong, but the judge is looking at it with nothing else to do. This is the same thing when some people file family offense petitions in family court. Okay, the situation you have is when these family offense petitions get filed, just like these custody petitions get filed like this, the court looks at it, they say, okay, I have to protect the child. So therefore, since I have to protect the child, I'm going to sign this, but I won't be able to see him for 5 weeks, and you might have, I've had dozens of times where the other party says, Mike, this isn't true. I didn't do this. I mean, she's doing this, this didn't ever happen, or this happened, but not the way this person he or she said it happened. But now that person is sitting out there 5 weeks without seeing his kids. Okay. And that's something that we have to change.
So our second course code is 509861. Again, it's 509861.
Why don't we do some questions? How's that? Sure. The question was, what does the court really look at if someone's looking for sole custody? Like I said, in my close to 30 years of practice, I've had 2 cases where the parent won sole custody. So you have to actually show that the other parent doesn't see the child, doesn't really communicate with the child, doesn't ask questions regarding health, education, welfare. They never go to the doctor. You try to call up the other parent and you say, geez, we have to go to the hospital. And he just doesn't do, the other parent does nothing, or he just doesn't return your phone calls. The other parent is severely alcoholic, drug addict, violent, a lot of domestic violence in the home, no communication. That is very hard, very, very hard to do. And most courts will not do it unless there's substantial proof of these type of things.
When and under what conditions will a court consider facts and circumstances pertaining custody that predate the prior custody order?
Okay. They will not do that because here's what they say. They say we had an order from a year ago, and prior to that, let's just say there were some issues with some arguments that they had, maybe a CPS-based investigation that came back founded, possibly maybe some, arguments between the parties. The court looks at it and says, listen, you knew all about this stuff and these actions when you agreed and we entered into this order. Okay, so they usually aren't going to let you rehash that again unless this is a continuation of conduct prior to that order. So let's just say, okay, pick one of the parents, they, drinking a lot, but, trying to get it under control. They're in AA or something, or they were trying to, get themselves straight. And so you thought to yourself, okay, he's probably drinking too much. All right, so, but you knew that and you entered into whatever order this might be, unsupervised time. Okay. Then all of a sudden, the parent goes off the wagon, starts drinking a lot. Okay, back to the same old thing as they did before. You can use that to show that there's a continuation of his prior conduct to show that, it's probably not going to stop. It's not a new event. Uh, Same thing with domestic violence issues, those type of things. That's when you usually go back and look at things like that. That's a question I get all the time. Well, sure. The legal answer is 18 when the child becomes emancipated and is an adult. Okay. So that's the legal answer. The real answer is, and I always tell my clients, well, when you look to a child that's, 15, 16, the court's going to take their wishes into account. But remember, they're not going to take their wishes into account if it goes against the best interest of the child. But what I mean by that is, let's just say, okay, I have a 16-year-old son, okay, and every time he comes to my house, man, we hang out, we smoke some pot, and we have some drinks, and we do this, we do that, So all of a sudden, the 16-year-old son goes to mom, hey, I'm gonna go live with dad, and she goes, well, I just want to live with dad. I'm 16, I can do it. You can't tell me not to do it. So dad files a petition, and all this comes out, and the court's going to go, no, it's not happening. Okay, I'm not changing the third and custodial order just because you're 16. You like to go to dad and smoke pot and hang out and drink beer with them. All right, it's not happening. Now, then the second thing, the judge is going to say, but Mr. Belsky, as we all know, what I'm going to do with a 16-year-old, I'm going to really have the colony police go grab him by his shirt collar, drag him out of the house. Dad's like dragging him back to mom's. When we know for a fact he's just going to turn around and go back to dad's anyway. So you're at this catch-22, Mr. Belsky. And so how does that then relate to something else? Well, then that also relates to possibly child support issues and different types of things you can look at. But I usually say 15, 16, nothing younger than that. Because I've had plenty of judges pretty much say, that child does not determine the best interest. I determine the best interest. So I'm thinking if you really want to pick a day, 15 and above, okay, something like that.
It says,
Brittany,
how
what
long
that?
should we reasonably be expected for a custody order to last? 5, 10, or 10 years? And then also, can grandparents be a part of custody agreements?
Yes. Okay, sir. A custody order will go until the child turns 18. New York state law says once a child turns 18, they are an adult. There's no such thing as a custody order after the child turns 18. Now, you still have to support your child beyond 18, but there's no such thing as a custody order. All right, that's the first. Secondly, grandparents. Yes, New York state grandparents have grandparent rights. Okay. And they can attempt to file for custody or some type of visitation rights. Right? Now, grandparents filing visitation rights and grandparents for custody, that's a whole other ball game with a lot of twists and turns. And grandparents, yes, they can be part of custody orders. All right. But there's a number of things you have to look at in custody orders. First thing you have to remember, the mother and father have superior right over anybody regarding what to do with their children, who can see their children, what happens with their children. That's the first premise you have. All right. Now, that can get taken away, of course, by Child Protective Services of the county for neglect of a child. That can also get taken away by a grandparent who files for custody of their grandchild based upon the mother and father being so inadequate that they cannot take care of the child. And it's in the best interest that a grandparent takes custody of your child. All right, but that's just a brief overview of those two things.
Changes the job and it affects the schedule, is that enough to go back to court to accommodate?
Yes. Okay. So if you have it, but you have to show why it's in. Okay. So basically, you have a job, and it changes. Now, did it change because you changed it? Did it change just because the company changed it? So there's a couple things to look at it. Okay. If you change your schedule because you wanted to change it, is that enough? No, because you're the one that did it. But say your company says, okay, Mike, you're on the night shift, but we don't need you on the night shift anymore. We're moving you to days, and that's just too bad. You got to do it. Is that enough to get you back into court? Of course, because it's going to affect your time with your child. Okay. So this change, number one, it's a change of circumstance. Number two, it's in the best interest of the child to go back to court to rework your schedule so you can see your child. At what age is child support payments in? Well, that's a question again for about an hour's worth of talk, but it either ends at when the child's emancipated, okay, which is 18. If the child is going to college and school, it doesn't terminate. If the child is over 18 and is working full time, it could terminate then. Okay? If the child goes into the military, it terminates. If the child starts residing with somebody else, their partner on a full-time basis, okay, it can terminate then. So, but then it could also terminate basically if, let's just say your 18-year-old daughter hates you for some reason, God only knows why, okay? You've tried to keep contact and try to get in touch with your daughter, but she does for some reason just won't talk to you, wants to see you, won't do anything. You can emancipate your child. And that's called self-emancipation. You look to terminate child support. And again, same thing. Let's say mom or dad, the child is 18, lives with mom or dad. Let's say they are going to college or something. Okay. Then you could say that the mother or the father, as such, their actions have alienated my child from me because of their actions, nothing that I did. And I tried to talk to my child, but the mother just turned that child against me. You can file and terminate the child support paid to the mother. That's kind of very broad, and we could have a whole couple hours conversation about that. Like I said, if anybody has questions, about this or something, or if you have issues, give us a call. We'll talk to you.
Thank you everyone for joining today's presentation, and thank you again, Michael. Please make sure that you complete and return the course evaluation and affirmation to CLE@tullylegal.com within the next 2 weeks to receive your certificate of attendance. Thank you everyone for joining today, and have a great day.
Thank you. Bye-bye.